recent headline blared what many conservatives already suspected. Lower courts blocking Trump's executive orders at much higher rate than predecessors. According to news reports, the lower courts have slapped at least 15 national injunctions against President Trump so far this year. And he hasn't even been back in office a full year. Now, many legal experts noting that this dramatically outpaces the 6 against former President George W. Bush during his entire presidency, and the 12 against former President Barack Obama, and the 14th against former President Joe Biden for their entire time in office. Is this a case of revenge of the deep state? Is it manipulating the judiciary in order to stop the executive branch and the legislative branch? Well, here to discuss this, Travis Weber, Vice President for Policy and Government Affairs. He holds a JD from Regent University School of Law. He's also graduated in international law and a certificate in international human rights law from Georgetown University Law Center. Travis, welcome back to Washington Watch. Thanks for joining us.
Tony, thanks for having me on.
All right, so there is a remedy. The House is going to be taking up a bill maybe this week, although it's going to possibly be a short week, but a bill by Darrell Issa that would restrict a district federal court from issuing a injunction for the entire nation and not just the parties that appear before them.
Yeah, that's true. Yeah, I mean, this is the issue of nationwide injunctions has become an increasingly hot, contentious topic in recent years as administrations switch parties, Republican and Democrat. The uptick and use of nationwide injunctions has been a trend. And so if we examine constitutionally what the Constitution prescribes for how the balance of power is to be regulated between Articles 1, 2, and 3, the legislative, executive, and judicial, there's some guidance there in the Constitution. And it provides that Congress can regulate the federal court system pretty extensively. There's a Supreme Court that's prescribed by the Constitution, but in large measure, other than that, Congress can regulate the courts. And so,
because they're a creation of the Congress, correct?
The federal lower courts are a creation of Congress. Only the U.S. Supreme Court is a creation of the Constitution. So this bill is a exercise of the constitutional authority granted to Congress to regulate the lower courts, and it's a permitted legal constitutional exercise of that authority, and saying federal courts need to stop their nationwide injunctions. And Tony, the reason, so even if we explore what these are, right, historically lawsuits dealt with a case or controversy between parties where there was an injured party saying, here's how I've been injured, why I've been injured, and the amount, et cetera, the damage to me. And courts would issue a ruling and prescribe a remedy between the parties. But a nationwide injunction applies to everyone nationally, regardless of whether they are a party to the lawsuit, regardless of whether they've been personally injured. They're subject to the nationwide injunction. So it's a huge, it's a huge step of where we've come.
And we've also seen something that's been happening is that there's what's called venue shopping, where they will take, and both sides, all right, in complete candor, both sides do this, but it is exposing a weakness in our system where someone will go to a favorable jurisdiction where they've got a judge appointed by a Republican who's conservative. They take the case there, get an injunction, hoping it'll be across the country, an injunction across the country, the left doing the same thing. So this would cut both ways. This would say, no, you can't do these nationwide injunctions. It's only, you've got to appeal it to the next level, to the district or to the circuit court, and then to the Supreme Court, and let the system work the way it was designed.
That's right. And that forum shopping of selecting a favorable, jurisdiction. I mean, at one level, you can't blame the lawyers for representing their clients and trying to do that. On another level, if you examine the impact of the system, which we're really talking about here, there is a significant impact when that happens, because it has the effect of altering the national policy on matters that an elected president and his or her administration have proceeded to do in accordance with the will of the people that they've been elected to execute. And so the nationwide injunctions, the forum shopping, it tilts and adjusts that paradigm.
Well, and this could take months, if not years in some cases, to work its way through the judicial process, correct?
It can. And so in the meantime, a new policy has been just prescribed at the hands of the judge issuing the nationwide injunction, right? So if we kind of take those off the table, what do you have? You have parties who've been injured, who have claims, they bring them to the courts, and the courts issue remedies. So require injured parties to go before the courts would not otherwise alter that method of operation, apart from taking the nationwide injunction off the table, and those cases would go on up through appeal. But that's the way historically cases have dealt with, and there's a reason that cases or controversies impliedly between two parties have been brought to the courts. And so this would say, let's kind of move back in that direction and stop having courts basically reissue national policy in the meantime until the matter works its way up on appeal.
So Travis Weber, in reality, under the way this is functioning right now, is that we have unelected district-level judges essentially setting policy for the country.
You effectively have that, especially when you look at the fact that the nationwide injunctions, after the injunctions have been issued, you have a new national policy until there is an alteration of that injunction. So in that sense, there's a out of step. We're out of step with the Constitution, where the executive branch is supposed to take action in certain areas according to the will of the people who've elected someone to president. So there has to be, we have to look at the Constitution's text and get back to recognize the limitations and what Congress is authorized to do, regulating the courts.
Travis Weber, thanks so much for joining us and explaining it for us.
Thank you.